right, well, thank you guys for having me up here today. I'm not going to do my big introduction because y'all know me pretty much. For the benefit of the video here, I'm Jeff O'Brien, attorney with Lohman Abdo, which is a downtown law firm. Actually, we've got offices in Hudson, Wisconsin, and one office in New York City. We have an entertainment law practice too. But what I'm going to talk about today is a lot of common legal issues that can trip up business owners. I know all you guys are working with business clients and trying to help them, improve their business, improve their cash flow, help grow the business. And these are things that over the course of almost 12 years of doing this now as an attorney, these are kind of common things that I've seen trip people up. Sometimes it happens because they're not using an attorney, or they have an attorney and only you keep them on a need-to-know basis. So these are some things that in law school they teach you the law by issue spotting. If you're given a fact pattern, you have to issue spot the issues and then analyze and everything like that. So what I'm going to do today is give you guys the tools so you can issue spot situations with your clients that you're working with to say, hey, stop, you got to think about this, and sometimes you need to talk to an attorney if they don't have somebody. So I call it Business Law 101 for business coaches. I used to call it Why the Heck Do You Need a Business Attorney? It was a little bit less sophisticated program. It was basically designed to scare everybody in the room to hire me. So this way I'm teaching you to delegating you to be surrogates to scare people to hire me. So what we're going to talk about today, we're going to talk about 5 things. We're going to talk about entity formation, using an LLC or versus an S corporation. Those are the 2 most common entity forms. They will go through what they're all about and why you would use either one and why would you use any of them. We'll talk about the importance of having contracts in writing, sometimes where it's legally required, sometimes where it just makes sense to avoid a legal dispute down the road. We'll talk about why would you have an attorney to draft the contract rather than just do it yourself, and some issues that we're trained to think about that maybe a business owner isn't trained to think about in terms of kind of mitigating some issues that could arise later on in the business relationship. We'll talk about a little bit about trademark registration, the legal mechanism to protect your company's brand. We'll talk about that. And then we'll talk about one that comes up time and again. We'll close with this one, the issue of worker classification, which is someone an employee, is somebody an independent contractor, and how do you get somebody into one of those baskets? It's an area that's fraught with problems if somebody gets it wrong. So we'll talk about first the common mistake number 1, which is operating your business without a liability limiting entity. It's getting better, but it's surprising how many people still do either nothing or the bare minimum. So why do you want to form an entity? Well, the obvious one, you want to shield your personal assets from business liabilities. Historically, in the world of entity formation and business law, we had originally 2 different forms of entity. You had a partnership, which today we call our general partnership, and you had the corporation, which is known today as the C corporation. And they were distinguished this way. Partnership, you were personally responsible for the obligations of the partnership, but you didn't have a separate level of tax. You had all the profits and losses prorated out to the individual partners. The corporation side, initially it was you had a liability shield, which was the cool part about it, but then you had double tax. The corporation would pay tax and the shareholders would pay tax on dividends. Over time, that's evolved where we now have 2 different forms of corporation, the C corporation and now the subchapter S corporation. It's called the subchapter S corporation because of its place in the Internal Revenue Code. And of course, not surprising, C corporation is from the subchapter C of the Internal Revenue Code. And then we have about 3 different forms of partnership. We've got limited partnerships, limited liability partnerships, limited liability limited partnerships, still have the general partnership, and then they have this thing called the limited liability company, or LLC. So there's a lot of different forms these days, but the dominant 2 for small businesses are either a limited liability company or the subchapter S corporation. So that's why you would form one, is to shield your personal assets. But a lot of people think, once I file the form articles with the Secretary of State and go on the IRS.gov site and get my tax ID number, I'm good, I'm golden, all my assets are secure, my personal assets are secure. It's not the case. There's a lot of other paperwork that goes into setting up an entity that a lot of folks don't have, and I tell people, guess what, you can't find it on the internet. And people have tried. I actually have had people, I did my own bylaws. Why don't you let me see them? And it would be for a California corporation. So, well, the notice provision, there's a whole bunch of different provisions in in California's corporation law that Minnesota doesn't have, and so these don't really work, and then you have to throw them out and start over. So there's things like bylaws, how how meetings are run and things like that internally. Who's paying for what percentage of the company, all those things, you have to have those documented. And what happens is, if you don't follow the corporate formalities, having written documents, mixing personal and business funds in one bank account, all those things, what happens is, if you have a creditor issue, a creditor can, we call it, pierce the corporate veil. Now, I'm not going to go into great detail, but one of the handouts in the packet talks a little bit about veil piercing. Simply put, it's a way for a creditor to get through this liability shield that the entity form provides over a business owner's personal assets and lets them get at the business owner's personal assets. It's not an easy thing to do, but in Minnesota, like a lot of states, the bar to get into court with a lawsuit is very low. So if someone can still try to sue a business owner on a veil piercing theory, they may end up winning the business owner and defending the case, but they'll spend a lot of money in the process and could end up jeopardizing their business's future. So we'll talk first about the subchapter S corporation or the S corp. Now, if someone's going to do a corporate entity, that's usually the one they're going to do if it's a small business. There's tax reasons why you do a C corp. Big companies are C corporations. Most small businesses, if they're going to operate under a corporate form, are going to be an S corporation. So the keys here with the S corp, you have to make an affirmative election with the IRS. There's a form that has to be filled out. All the shareholders have to sign it. You have to tell them how many shares they're subscribing for, what their social security numbers are, all that kind of stuff. Sign it, and you forward it into the IRS, and they give you a confirmation that it's been received. There's restrictions on who can own shares of an S corp, and this is one that trips up a lot of folks. I work with a lot of clients that are looking to raise money from outside investors, and we most of the time will set up those companies as LLCs because you basically have to be a resident of the U.S. and an individual if you're going to own shares of an S corporation. So if you have somebody that wants to invest in your company via their LLC or their corporation, you can't do it with an S corporation because now you automatically default to becoming, they call it blowing your S election. You're automatically a C corporation. You're subject to the double tax. Shareholders have the same rights in an S corporation. There is no, you have this class, we have this class. It's one class. You can distinguish between voting and non-voting, though, in an S corporation. The advantage of an S corporation, and this is more for an operating business versus like a holding company, like a passive investment entity, like a real estate LLC, would be possible self-employment tax minimization. We'll talk about that a little bit later, but there's a way you can minimize the self-employment tax as opposed to the LLC form. The LLC, it's a little bit more flexible. I would say the LLC is becoming the dominant entity form. A lot of times I think it's because if you have a single owner business, what's cool about it is it's disregarded for income tax purposes. There is no separate tax filing for a single owner LLC. People just itemize the income from the LLC on a schedule to their personal tax return. So from an administrative cost standpoint, if you're a brand new business owner, you're a single owner company, an LLC is a cost savings even over an S corp, because even an S corp you have to actually file a separate return. For some people that's an expense they don't want to take, so the LLC form is nice. You can vary allocations of governance rights and financial rights. This is a cool thing. If you want to have, say, you have two people coming into a business and they want to have 50-50 ownership, but say someone put in 70% of the cash into the company, they want to split the profits 70-30, but for whatever reason they want to agree to, they're going to have equal say on the governance side. With an LLC, you can do that. You can sever governance rights and financial rights. Governance rights being voting, financial rights being share of profits and losses, and you can allocate it that way. So that's one of the advantages over an LLC. The drawback, as I alluded to before, you pay self-employment tax on every penny that comes into the LLC, whether it be salary, whether it be profits. You can call it a salary, whatever. You're going to pay full self-employment tax. The differences between the two, the FICA tax minimization. With an S corporation, the owner, you can have a president. They require you to have a president. The president can pay themselves a salary. It has to be reasonable for the industry. and they pay FICA and Medicare tax on the salary portion, and any draws they take on profits above the salary, they only pay Medicare tax. There's a tax savings. So I always tell people, at some point have the conversation with your CPA, and there's a point where it might tip, your profitability might tip the scales to make the S election. And the cool thing about well, what do I do if I flip later on? Well, number one, Minnesota statutes actually allow a conversion between an LLC and an S corporation within their corporation and LLC laws. But also, it's as simple as filing an S election with the IRS. You can have all your documents be an LLC, and as long as you meet the criteria for being an S corporation, you can still qualify to file your subchapter S election with the IRS. So, it's a cheaper way of doing it rather than having a full conversion. The salary part has to be reasonable with the S corp. There was a tax court case a couple years ago where someone actually took $220,000 out of the company, $20,000 being salary that they paid full self-employment tax on, and $200,000 being draws. And the IRS said that's not reasonable for your industry. You have to have a greater portion allocated to your salary, not taking, you're just setting this thing up in a way so that you don't have, you can minimize your self-employment tax, and we're not going to let you do that. The documents for the two entities are very much the same. You have articles that you file with the Secretary of State. For a corporation, they're called Articles of Incorporation. For an LLC, they're called Articles of Organization. Corporations have bylaws where it talks about how shareholder meetings are held, how board of directors meetings are held, what are the officer titles, what are their duties, all those kinds of things. LLC has the same thing. Some people call it an operating agreement, some call it bylaws. Minnesota's LLC statute is very much parallel to its corporation statute. We're unique in that regard. You look at a lot of states, even across the border in Wisconsin, and their LLC statute looks much more like a partnership act, and their LLCs function more like partnerships. They'll talk about, are you member managed or manager managed? It's a little bit different than having this board concept like Minnesota has, where corporations have a board of directors. LLCs in Minnesota have a board of governors. So it's very similar in terms of its operation to a corporation. You have initial written actions ratifying all the acts of setting up the company, and everybody signs off on that. You also have a control agreement. On the S Corp side, it's a shareholder control agreement. On the LLC, it's a member control agreement. Hugely important document, especially when you have multiple owners, because that's where you're going to find your buy-sell provisions. And right now, I think we've got 3 or 4 cases in the office right now of relatively newer, smaller companies with shareholder fights. And some places where they do have documents, some places where they don't, some places they had some provisions that we didn't draft, but they were a little bit ambiguous. These owner disputes can quickly escalate into 5-figure legal disputes and possibly beyond. The buy-sell agreement, I always call it the business prenuptial agreement. Settle everything up when everybody's on the same page, and I get this from clients a lot saying, oh, we totally agree on this, that, and the other thing. So when you're starting out, you agree on everything. When it doesn't make money, or when it makes more money, you're not going to agree on everything, and you're going to start having fights. And that's when this document comes into play. So you have your events like what happens if someone wants to sell their shares to somebody else, if somebody files bankruptcy, if somebody gets divorced, if somebody dies, if somebody is disabled, all those different things. I work with a lot of real estate folks, real estate practice. A lot of times they'll have in their buy-sell agreements if someone has their license suspended. Same thing with financial services, veterinary clinic. If you're a licensed business, they could have triggers in there where if you have ethical discipline or a license suspension, that could be a trigger to buy out your shares at a reduced rate. And then finally we have the tax forms with the IRS. You have the SS4, which is the tax ID number application. It's nice. The IRS you can do that right online now. You can actually, as of I think about 2 weeks ago, you can actually file your articles with Secretary of State online, and within the hour almost, you get an email back with the PDF of your certificate of organization and your filed articles. Before it was a week and a half turnaround waiting for that you got to pay for a service to expedite it. Not anymore. They've brought their computer system up current now, where you can get an almost instantaneous email back with your final documents. So those two things can be done online now very quickly. And then with the S corporation, like I mentioned before, there is an S election form. It's called 2553, where everybody, all the shareholders sign it. The president signs it. We submit it to be actually recognized as a subchapter S corporation. In terms of the mistakes that people make in this area that folks like myself can help them avoid, the state provides a form of articles on its website, whether it be for a corporation or an LLC. It's the bare minimum. It says what's the name, what's the registered office, who's the registered agent, what's their phone number, sign it, send it in. Here's the fee. That's fine, and that's enough to get somebody formed, but there are other things that you can provide in your articles, such as some indemnification provisions, some written actions without a meeting, so some different, name the initial governors or directors, whatever the case may be. There's some default provisions that are in the corporation statute and the LLC statute that say, unless otherwise provided in your articles, this is the rule. And so some of those things we waive out of, these arcane concepts like preemptive rights, cumulative voting. I'm not going to go into detail what they are, but suffice to say, most small businesses don't need those provisions. So it's much easier just to go into the articles and say there are no preemptive rights, there is no cumulative voting. So those kinds of things that you want to have the default provisions addressed in the articles that an attorney-prepared set of articles will address. The other one I mentioned before, incomplete documents, not having bylaws, not having a buy-sell agreement, not having any record of any share certificates even, or listings, a ledger of who owns what and what they've contributed. Things like that, very common, believe it or not, to have happen. And then when in the S Corp realm, failure to timely file the S election. The S election has to be filed within 75 days of the start of the business. And so as a practice in our office, we won't file the articles until, and you have to submit the original signed S election form, the 2553 of the IRS. We won't file the articles for an S corporation until we have the original S election form in our office, in our hands, ready to file, so that we are not creating a situation for our client where they are now going to be, by default, a C corporation because they didn't file it on time. Our malpractice carrier prefers it that way, that we wait until we actually have that form back before we start the clock running on when they have to file that. So those are the kinds of things that I've seen, and I've had clients where we just basically have to scrap the entity, start over again, because they've let lapse and now they're a C corporation, and saying I didn't know any better isn't a justifiable excuse to the IRS to get an extension of time. Moving out of the entity formation and into contracts, one of the mistakes I see over and over again, entering into verbal or handshake agreements without a written contract. I had a question from a client this week: is a text message enforceable? And my answer was, it can be, yes. Depends. Minnesota has a law, the statute is called the Statute of Frauds. It specifies what contracts have to be in writing to be enforceable in the state of Minnesota. A couple of things that jump off of here: contracts involving the sale of real estate. Obviously, purchase agreements, those types of things have to be, option agreements have to be in writing. Contracts for the sale of goods worth more than $500, those have to be in writing to be enforceable. Contracts that can't be performed within a year, and also leases for more than 1 year. So that's why leases have to be in writing. And it's amazing how many people have verbal leases in this day and age, but you do have to have, if it's for a year or more, it has to be in writing. So those are the legal reasons. Those are the situations where the law says it has to be in writing in order to be enforceable. Meaning, if somebody breaches whatever verbal agreement they had, the party the non-breaching party is going to be SOL going into court because it wasn't in writing. You can't go back on recollection. Now you can piece things together, emails, things like that, to make a document. If you can ferret out the definitive terms of the agreement, it not necessarily has to be all in one writing. You don't have to have a document that says agreement on it and everything specified out. But if you can have multiple writings that together piece together an agreement or a contract, it can be enforceable. But the bottom line is handshakes and verbal agreements in these situations don't work. There's also non-legal reasons, I call it, for getting your contracts in writing. It can avoid further, future legal disputes. It makes good business sense because it makes sure everybody has the same expectations. It's clearly defined on the contract what the relationship is going to be, who's going to provide what to whom in terms of services or goods. It's clear. It's defined. There shouldn't be any question. You can also specify remedies for what remedies are available. For example, if you have a employment agreement with a non-compete, okay, the party that's trying to enforce that may want to have the ability to go to court and get an injunction against the employee for going to work for a competitor, something like that. Trade secrets as well. If someone misappropriating trade secrets, they may want to be able to file an injunction against the party that's breaching that agreement. The other thing that's a key thing these days is alternative dispute resolution provisions, arbitration, mediation in contracts. I recommend to a lot of my business clients to have those kinds of provisions in their agreements for the simple fact that business disputes in court end up sitting at the back of the line because courts are swamped, their budgets are tight, they have to deal with the criminal arraignments and some of the parking tickets and all that kind of stuff. That's what they have to do first in the order of things, in part because they have to generate more revenue for the courts and the state to run. So those take a front seat. Business disputes sit and take a little bit longer time to be heard, and of course your business can stop depending on what's going on with whatever, if you've got a shareholder dispute or something, it's kind of hard to operate your business when the owners can't agree on anything. So I always tell people, I said, it's a really good idea for us to put in a mediation provision or an arbitration clause or something in there to take it outside of the court system if there's a dispute and get that dispute resolved expeditiously and in a less costly way, so that they can get on with their lives, get on with their businesses. So I highly recommend putting alternative dispute resolution provisions into garden variety agreements simply to streamline any kind of a dispute resolution should one arise rather than going through the court system. The other example I always give for folks in terms of remedy that can only be specified in a written contract is attorney's fees. A lot of folks come to me and they get these emotional disputes with a business partner or somebody else, someone they had a relationship with, and they want to sue and get their attorney's fees. And of course, they always want to get their attorney's fees because we're expensive, right? Especially on the litigation side. The problem is that in Minnesota, like most states, the rule is that absent a statute or a provision in the contract that says otherwise, you pay your own attorney's fees in court. And so an example of a statute, mechanics liens. Someone does work for somebody, improves somebody's property, they don't get paid, they can file their lien. If they have to foreclose the lien, they can get their attorney's fees. That's what the statute says. Somebody just breaches an everyday agreement to provide services, there is no statute that says that you get your attorney's fees. I always talk about this example. I had this case many years ago. A client was providing consulting services for a company, was owed about $4,000, and they just stopped paying her. In her consulting agreement that we had drafted for her, she had a clause in there that said if she ever had to enforce or the contract or pursue the other side for a breach of the contract, she could collect her attorney's fees. At the end of the day, even in small claims court costs money, our attorney's fees exceeded the amount that she was owed. At the end of that case, the other side cut her a check for what she was owed plus her attorney's fees. So she got paid. If she would not have had that clause in the agreement, she would not have been. She would have lost. It would have been a loss for her because she would have had to eat that $4,000 that she was owed because the attorney fees would have overwhelmed it. It also makes a nice incentive towards settlement of a case when someone knows that they're on the hook for the attorney's fees because the meter keeps running. So you can actually use that as a way of saying, on the other side, you might want to settle this sooner rather than later because our meter is going to keep running for our client and you're going to end up paying them. So that's one of the examples that you have to have an attorney's fees provision in the contract. Now some people come to me and say, well, I'm doing a deal with a big Fortune 500 company and I'm doing consulting work and they aren't going to let me have the attorney's fees clause. And I said, that's fine. It's a risk-reward decision you have to make. If If you think that, I mean, I said, I give you the advice, I point out the risks. I don't kill your deal if you think that that's economically beneficial for you to do that contract with somebody. If you think, you know, working for, say, Target or 3M or Medtronic or whoever doing consulting, if you believe that that you're not going to, there's a less risk that you're going to have a breach of their payment obligations, then yeah, by all means, sign their, you know, sign their standard form or whatever, and we'll go from there. Because some of those big companies, that's what they insist on. You're going to sign our agreement. You do what you can, and you have to make that. You know, ultimately the customer, the client has to make the decision. But I always try to get the best provisions in there, like attorney's fees. Common mistake number 3. This is one that's near and dear to my heart: drafting a contract yourself, or not having your business attorney review the contract. I tell folks, I am fine with you taking the first crack at drafting your agreement, because you know your business, and it probably saves me a little time trying to guess what different industry nuances and things need to be in your contract, but at least let me see it. And a lot of times I have pretty sharp clients, so they'll put together a pretty decent contract. They've probably taken it from some other contract or something they've found online or whatever, and it's in pretty good shape. But we fix it up a little bit, put a few provisions, and there's always room for revisions and editing for it. But I still want to see it. I said, I get it. You're on a budget. You don't want to pay me to draft it from scratch. That's fine. Let me just see it. Some folks don't even do that, and that's when you have problems. And one of the most common ones is signing contracts in the owner's personal name rather than the company's name. You spend all the money to have me set up an LLC or an S corporation, and then you go out and sign an expensive contract which obligates you personally because you signed it in your own name rather than setting it up with the signature block by so-and-so president, XYZ Corp, you know, that kind of thing. Common mistake. And actually, when I tell clients, when they want me to review a contract, actually the first thing I do is not start at the top. I go to the back. It's the first change I usually make is, well, they got it in the wrong name. They got it in your personal name, or they have it in the wrong entity. It's got to be this one. Ambiguous contract terms. Folks trying to draft things themselves, as I said, draft it yourself, let me see it, because we can give provisions legal effect. Sometimes somebody thinks that they make it clear, but to an outside party or a judge, whoever, it may not be clear, and what the law doesn't like is ambiguous contract terms, because now you've got a he said, and you're in court. And like I mentioned before, lack of adequate remedies. Attorney's fees clauses, no provisions for injunction relief, no ADR clauses, things like that. Those are the things that, you know, we geek out on in terms of having those clauses in contracts that we want to, that the average business person is probably not thinking, oh, I need to make sure I have a tight alternative dispute resolution clause in my agreement. No, that's what we're paid to do. We can put those things into contracts. Common mistake number 4, not properly protecting your business's brand through trademark registration. One of the industries that I work a lot in these days is in the craft brewery industry. We have well over a half dozen craft brewery clients, and beer names are really competitive right now. There are so many of these craft breweries, microbreweries out there, and everybody wants to have the cool name. And we're actually filing trademarks on their beer names at about the same time that we're setting up the entity and filing a trademark on the brewery name itself. And we have had some disputes between breweries where, hey, you know, you're using my name and it's a similar beer to mine, because it's causing confusion amongst the consumer. That's the big issue with trademarks, is confusion in the marketplace. If somebody is out there using a similar name for a product or a service or their company, that's, you know, the classic example is somebody calls the wrong company thinking they've got the first one, or they have a customer complaint and they send it to your company, and you find out that right around the corner someone's operating with a very similar name. That's the kind of confusion that trademark laws are meant to prevent in terms of eliminating any kind of confusion. Trademarks, there are state trademarks, but by and large, you file a trademark with the federal government, with the U.S. Patent and Trade Office. What the benefits of trademark registration? A trademark is a brand name. This is actually from the Patent and Trademark Office website. It's any word, name, symbol, device, or any combination that's used or intended to be used to identify and distinguish the goods or services of one seller or provider from those of others, and to indicate the source of the goods or services. So like the beer names are a classic example. Distinctive words. It can't be descriptive, but distinctive words can be trademarks. For example, I'll give you one. I started doing a couple years ago this little radio show for some real estate stuff, and we came up with something called the Legal Minute, and it was just kind of a way of educational PSA about something about real estate law. Well, we actually filed a trademark on it, and they granted that for us. They said that wasn't descriptive, that what we were doing, it wasn't, they let us have the trademark for that, so our firm owns a trademark for the Legal Minute that we air on the radio every weekend. There's a great article in the packet. I have to give credit to my colleague, Greg Perlberg. I put his card in the packet. I said, I'm going to plagiarize your trademark article on my blog, and I'll start passing it out and giving you credit and giving your card out at the same time. So he's our trademark guy at the office. Been working. I actually switched firms together. So I've been working with him for several years, and it's amazing what's in that man's mind in terms of trademark law. So that's something that if someone has a brand or a slogan or something that is a key part of their marketing program, it's worth talking to a trademark lawyer like Greg to find out if it's protectable. You don't want to have somebody else start using a similar name and then having a key piece of your brand strategy go out the door because a competitor is using it and diluting its effect for you. How do you register a trademark? Pretty simple. First step is go on to the Patent and Trademark Office website and search to find out if anybody else has registered it or filed anything on it. And there's a really great database on there. It'll tell you, is it live, is it dead, is it pending, and you can search there first. I always tell people you want to go there as part of the search for your business name, because you don't want to pick a business name, buy stationery, buy cards, do marketing collateral, all this stuff, and then find out, oh, by the way, somebody else has a trademark on that name in the same field, you can't use it. You don't want to have that and have to basically throw out all your stuff you just paid for and start over again. You got to complete the appropriate application. You can file as an intent to use or an actual use. If you file an intent to use, meaning you aren't using it in commerce yet, you have to go back within, I think, 6 months to the trademark office once it's been granted and show that you're actually using it in commerce. Actual use is a lot easier to do. We typically recommend that we want to file actual use applications. You have to pay a filing fee. In most cases, it's $325 per class per mark. In some cases, it can be a little bit lower than that, but it's a cost per class of goods or services that you're filing in. And then everybody asks, do you need to hire an attorney? And the answer is, no, you don't, but there's situations where you may want to have an attorney in the process, because it is kind of a complex process. A lot of times, everything kind of just sails through, and you get your certificate back that shows you're registered. But it's very common for the trademark office to come back with what they call an office action. They may have some challenge or inquiry or question about the application you filed, and most business owners, when they get that, will look at it and go, huh? That's when you would definitely want to have an attorney helping you if you get an office action back from the trademark office. Like I said, we have a lot of clients that will start using us for trademark stuff right out of the chute, along with their entity formation. It is a technical process. We try to keep the fees low and try to help the people navigate through. There's continued monitoring to make sure the mark doesn't lapse and stuff, because these can have, if you do it right.
I was going to ask that. Is there a period of time for which, like the duration of the trademark, and you have to renew it, or
No,
is it?
that's the beauty. There are some renewals. You do have to renew it from time to time, but if you meet those deadlines, a trademark can have perpetual duration, unlike a patent, which has a finite period of time.
Okay, that's the difference.
The trick in the trademark stuff is you don't, when you've seen it happen, there's common examples, you don't want to have the trademark name start to become the description of the product. Post-it notes, Xerox, some of those things that have become household names, Kleenex. You're going to lose trademark protection if it starts to become known as a description of the product. If you ask the Kleenex people, they'll say, no, that's facial tissue. Our trademark is Kleenex. Common mistake number 5, misclassification of workers. Employees versus independent contractors. I put this one in here because I've been dealing with this quite a bit as of late. Why does it matter? If the worker is deemed an employee, then the business owner the employer is responsible for withholding taxes. They may be eligible for benefits like 401k, things like that. A misclassified worker, I mean, if you're going down years after the fact and the business owner's been treating somebody as an independent contractor and the IRS makes a determination that they're an employee, you're going to have lots of back withholding taxes to pay. And you're going to have fines and penalties on top of that. And here's the fun part, of course, it's the IRS, right? They don't just have one factor to determine whether or not you're an employee or an independent contractor. They have 20. And those things, it doesn't say if you meet more than this, it just sways it. There are 20 things to consider. There's an article I put into the packet which lists out the 20 factors. The big thing is the level of control. What level of control is the business exercising over the worker? The more control, you're going to start sliding towards an employee. So, your independent contractor, it's going to be, you work, we're going to pay you hourly, you work wherever, you're responsible for your expenses, we'll 1099 you and you're responsible for your own taxes, things like that. But it's kind of, so a lot of times it'll be, you're not exclusive to our company. You can perform similar services for others so long as you don't breach any obligations of confidentiality and trade secrets and stuff like that. Employee is going to be, submit your expenses, we'll pay it, you have an office, you're expected to be here 9 to 5, 40 hours a week, here's your job duties, all that kind of stuff. I have an interesting case right now where some folks were deemed, their document says independent contractor, but yet there's a memo in the file from the head of the office saying you're required to be at staff meetings, and there's disciplinary proceedings if you miss them, all the way up to being terminated. That's more along the lines of an employee, not an independent contractor. Independent contractors aren't penalized if they miss the staff meeting. So that's one of those examples where someone wants to call it something, and it's actually something else. And I get that a lot. People ask me, how do I make sure, how do I make sure that I've got an independent contractor? Well, you can't necessarily. You got to look at what things you want them to provide for you, and when they're working, and how you're paying them, and then we can decide which bucket they fit into. And if it's the wrong bucket that you want, now you got to go back and revisit the whole relationship and reconfigure it in a way so that it meets the target you want to go to. Otherwise, you better be paying withholding taxes. So it's a tricky area, especially for the business owner in terms of, because everybody wants to have an independent contractor, right? They don't want to have to be responsible for paying for their health care and their workers' comp and withholding taxes and all that kind of stuff. It starts to add up for a small business owner. So they want you to be an independent contractor. The problem is if it looks like a duck, quacks like a duck, it's a duck. So you got to be careful of that kind of area. So consultation with somebody, when somebody comes to me and wants to do independent contractor, I start to really kind of dig down and find out what the relationship is, and before we go saying, okay, yeah, that's fine. Any questions about any of that stuff, or any other questions of stuff that I didn't cover?
Not about the content, but as I look at, as I look at our clients and how this applies to our clients, most of our clients already have formed entities. So the key would be the context of the entities relative to what it is they want to accomplish, and any benefits to doing it differently. I think for us, certainly making sure they have the right kind of agreements in place, whether it be partnership agreements, employment agreements, certainly the employee versus independent contractor. I think that kind of stuff is definitely valuable for our clients to be more aware of so that they can see where the gaps are, potential gaps are in the business. And then the key for them is looking at cost versus benefit, because, you know, from my perspective, or from our perspective, we agree with everything they are saying, and it's in our client's best interest of all of this is taken care of, because as you're well aware, the cost up front, even though it's a cash expense, is way less than the cost down the road when it happens. For us, and again, I'm sure you're probably familiar with this, it's, well, I'll worry about that when it happens.
Right.
Because it's more painful for me today to invest in this up front, or it was more perceived pain for me today to invest in this up front versus what the true cost of it is when it happens, because it's like lung cancer with smoking. Well, that happens to other people, that's not going to happen to me.
Right.
So how do you overcome some of that? Because I would be an advocate for making sure all of our clients are protected in these areas. The trademark registration one is something that I'm not familiar with, so I don't know how many of our clients really have things that they could.
I get the question asked occasionally.
Do you? So I don't know enough about that. Whether they really do have like processes or products, you know, like Jeff Murphy, for example, and their roadmap for how they do their design for their residential homes and stuff. Like that's something that can potentially be patented or patented versus trademark. And again, so I guess my first question then is how do you help influence their decision to invest in this, knowing that it's something like smoking where I'm not going to worry about what happens to me, and it's not going to happen to me that happens to other people?
Well, that's a really good question. A lot of times, you know, we meet with them as an initial consultation. We aren't on the clock. That's the first thing. Is they're always worried about talking to us because we cost money. So say, come and talk to me or call me on the phone. I'm not going to charge you to talk to me. And part of it is, in terms of getting them over the hump, I mean, some people are just not going to do that. But for others, telling them the stories of, the horror stories of some of the things that we've dealt with over the course of years is enough to, believe it or not, to get people to act. When they hear 5-6 figures of legal fees, that scares a lot of people. And they start to think, maybe I should do something about that. So that's a lot of it. There's some folks that are just, you just have to wait for the train wreck, and then they, when they pick up the pieces, then you can, lesson learned. Okay, now I'm ready. But you'd be surprised at how many people get it just hearing some of the stories of what others have had to go through. With your point about the people that already have entities filed, I do the same thing. I say, it's not going to cost you anything. Send me what you have for your corporate documents or your LLC documents. Let me just look at it. Because even if someone has formed their entity using the Secretary of State form of articles, we can always go in, and I think it's like $50 to file amended and restated articles, and give them the attorney-prepared form that we would have given them at the outset. If they don't have bylaws, we can just piece that in based on what we can help them kind of fill in the pieces in terms of documents that they didn't draft. By sell agreement, we can get that in place even after the fact. So a lot of times they'll just say, let me audit your documents, let me see what you have, and maybe there's no changes, but let me just, let me see what you filed. And I will tell you, probably 60 to 70% of the time, they have the articles from the Secretary of State and the tax ID number application to the IRS. And that's the only thing they have. So we help them, at a lower cost, put together, fix their articles, do the bylaws, do a buy-sell if they have multiple owners. So a lot of it is just, is to get them kind of, once they get them over the hump of seeing us as less of a commodity and more of that trusted advisor, and we do that a little bit by saying, just come in, just talk to us off the clock, and let's just have a discussion. And a lot of times people go for it.
And then I do find the trademark registration interesting because it's not something, honestly, that I've ever considered for our clients. How, under what terms would they want to register trademarks? And I guess what's the issue spotting that we would look for to suggest that that's the path that they would want to go down? Certainly if it's a business that is operating in,
say, multiple states. Now they definitely want to look at that as a piece in terms of their brand strategy. And of course that means also, are they selling goods and services online? Are they using unique slogans? Are they using words that aren't descriptive of the services they're providing, and are they using that as a key aspect of their marketing? What I always say, trademarks are a legal way of protecting your marketing strategy from your competitors.
With buzz builders.
Right.
Buzz builders probably want to trademark.
Right.
Yeah, exactly. So that's a brand strategy, and trademarks really go hand in hand. Trademarks are the legal means of protecting your brand strategy. So if someone has a very unique, very creative marketing strategy, a word, a logo, something like that, that is really key to their brand, that's something that should be at least looked at by a trademark lawyer as to whether or not it can be protected.
Okay. And who are your clients? What types of clients do you generally work with? And my guess is you can probably help most businesses, but who are the ones that you tend to get the best results in, or have the most expertise, or would be the best for you or your firm to work with?
Well, we're pretty much industry agnostic, but in terms of my practice, like I mentioned before, we've got kind of a niche area right now in like microbreweries, the hospitality industry. We have a lot of bars and restaurants and things like that. We work with a lot of folks like that. Any business is a candidate for us. Manufacturing businesses. I work with a lot of consultants, a lot of marketing consultants actually. I work with a lot of those folks setting up their company and doing a lot of times it's their consulting agreement, making sure that they have those provisions in there so that they get paid, and they get paid their attorney's fees if someone doesn't pay them, things like that. We work with, me personally, I work with a lot of folks on the real estate side, a lot of real estate investors, property management companies, things like that. I've got a little niche working with some retired professional athletes where the trademark thing comes into play, protecting their publicity rights and slogans and nicknames and things like that. The trademark area plays into that. But it is really across the board.
We had a conversation one time, Jeff, and you were commenting that your so-called ideal client or target client was probably a 10-plus employee type organization, and if I remember right, was it $500,000, $1 million in sales on up, or?
Well, it's probably ideal. I mean, I do work with a lot of brand new ventures too, setting up their entities and getting their contracts and stuff. I mean, pretty much I can work with anyone.
We tend to have more established businesses than newer businesses in our business. Generally, the newer businesses either are undercapitalized, usually need to start their business, let alone invest in business coaching services. And usually when they start, they're 10-foot tall and bulletproof, and I'm just going to figure it out, and I'm going to try it myself. And then if I need help, well, by the time you need help, it's going to be too late for you. But so we tend to work with more established businesses, those that have a level of cash flow and capital, and also have some battle scars, and they recognize that business is not as easy as they otherwise would think. So
a lot of my clients are folks that maybe have been around. I probably formed them 3, 5, or more years ago, and they've been with me since the beginning. So they're now in that. They might have been initially forming their entities, or they cleaning up documents and stuff, and now it's every once in a while the contract comes across. Can you review this? Or my lease is being renewed. Can you review this? And those kinds of things. And we do that stuff all the time. Or I'm bringing in a new investor. Can you help me? That kind of stuff. I said I can pretty much work with a business from cradle to grave, at any point in between.
Okay. So, Jeff, how do you see us being able to work together? Certainly, we're having you here today because I know you've had contact with us in the past, and through your relationship with Kevin, you kind of come back into onto our radar. We do. I mean, obviously we have a number of business owners, clients. We also coach an attorney's firm, and I don't know how similar or different the products and services that SPO offer.
They don't do a lot of business.
Yeah,
They
so
do a lot of business. They do